compelled to work in unsafe and unhealthy working environments. Forced resignation. This is one that happens a lot, especially in the financial industry. Let me start with this case of Ashana and First Bank of Nigeria. This is one very interesting case. So in Ashana and First Bank of Nigeria, the employee was the principal manager at the time she was employed, and a principal manager of the bank. And then she was invited one day to a meeting as usual and told that she should resign. In fact, according to her, she was forced to resign. Otherwise, they threatened that they would terminate her employment if she did not resign. So she had no choice but to resign. In her resignation letter, she wrote that, further to the management's request that I should resign, I hereby tender my letter of resignation. After that, she went to court. The court held that she was constructively dismissed and even awarded damages in her favor. Interestingly, the defendant, which was the bank, counterclaimed that, you know what, at the beginning of the year, this lady was paid certain allowances, which she's not, now that she has resigned halfway, she's no longer entitled to. And then the bank now counterclaimed that she should refund all those unearned allowances which the bank had earlier paid to her. The court said no. The court said that is not possible. You cannot eat your cake and have it. If she had remained in your employment and she was not forced to resign, she would have stayed, and this issue of repaying unearned allowances will not even arise in the first place. So the court even rejected that counterclaim in its entirety. Finally, where the mutual trust and confidence in the employment relationship is broken. Employment relationships generally are founded on mutual trust, confidence, respect, and cooperation between the employer and the employee. So these are some of the elements that are expected to exist in every employment relationship. And when these mutual trust and confidence are eroded, the employee might be forced to resign, which can be interpreted as a constructive dismissal. What are the legal effects of a constructive dismissal? The effects are straightforward. Since the employee resigned, it brings the employment relationship to an end. But because the resignation was involuntary, the position of the law is that that resignation amounts to a wrongful termination. And then in that case, the employee acquires the right to institution action at the National Industrial Court and to seek legal compensation in the form of damages from the employer or against the employer. And then depending on the terms of the employment contract, the terminal benefits of the employee become immediately due and payable. Now, it is important to mention that in succeeding in an action for constructive dismissal, the court pays particular attention to the special circumstances and facts of each case. So it is not every single resignation that will go to the court and the court will easily accept it, as I will show in the course of my presentation. So in the old dispensation, when we were largely bound by the common law, the employment relationship was largely deemed as a pure master-servant relationship, where the employer completely had the upper hand. The terms of employment were unilaterally dictated and varied by the employer. In fact, unfortunately, till today, we are still governed by an outdated Labor Act that does not address the intricacies and the evolved world of work that we are in today. And then sometimes, even in the financial sector especially, requests for resignation used to be seen as a way of doing the employee a favor, because sometimes in certain circumstances, you may have to report to the CBN if the employment of an employee is terminated. So in such circumstances, yeah, it used to be seen as if it was a favor. So you just call the employee and resign. Sometimes it is also used as a means to avoid certain legal obligations. But by and large, this position has changed. So since the 2010 alteration of the Constitution, there has been a significant transformation in employment law jurisprudence in Nigeria. People are now suddenly realizing employee rights. Employers, on the other hand, are starting to realize that this is no longer business as usual. The workplace now needs to be organized in such a way that the employer also manages the employee in such a way that both parties can peacefully coexist in the workplace. So now, because of this alteration of the Constitution, the National Industrial Court now have the exclusive jurisdiction over matters related to unfair labor practice, international best practices, and the court can even apply international treaties and conventions and best practices in reaching its decision depending on the facts of any specific case. More importantly, constructive dismissal, as I will show in the cases that we follow, is now characterized as a form of unfair labor practice, in which case, of course, the employee can now sue for damages. So there are several cases where the court has determined the issue of constructive dismissal. In Lawson and Keystone, it was a standard practice of the bank. So like I said, this is something that has been happening over time. So it was the practice, standard practice of the bank to just call employees when they want to declare redundancy and tell the employee to resign. And you see, many of employees just take it in good strides and just resign and go their way. But they did not realize the implication of what was going on. And in this case, the court held that forcing a staff to resign amounts to constructive dismissal by the claimant. In EC Celestina versus UBA, in this case, the lady was working with the bank, hardworking. Then all of a sudden, she was called to the regional office of the defendant and told to resign. She was not even told the reason why she was being asked to resign. She was not given a reason to defend herself, or she was told that she should resign. So this lady, in fact, at the time, the bank even started withholding her salaries. So this lady went back to her desk, typed out, I said, after my meeting with the company, I was asked by the management to resign. I hereby tender my resignation. Then she went to the court. She went to the court, claimed constructive dismissal. She succeeded, and the court awarded her 12 months salaries and even 3 months payment in lieu. Okoye and Access Bank is another very interesting case. In this case, the bank at the time was changing its group managing director. So the old group managing director, or the exiting group managing director, and the new group managing director invited certain employees, the Charles Okoye, and then 2 other people, one assistant manager and a senior manager, and invited them to a meeting, and one by one met with them and told them that, look, the group managing director is coming with his own team, so you are no longer needed here. Please go ahead and tender your resignation and please leave. In fact, before they even go back to their desk, they realized that they had been shut out from the computer system of the bank. They were not even allowed on the bank's network anymore. So they went ahead to type their resignation and even went to submit it to the head of HR. According to the claimants, when they went to the head of HR, the head of HR rejected their resignation letter and told them to retype it in the way that she was going to tell them to retype it. In fact, this is one of the things that the court looked at. So at the end of the day, the court looked at the treatment of the employees and said, their resignation, it was not voluntary. It was involuntary, and it is wrong to force an employee to resign. So the court awarded damages against the company and then declared that the employees were constructively dismissed. Then there are several other cases, indefinite suspension of employees. The court has also held that this amounts to constructive dismissal. I had earlier discussed the case of Oluwagbenga and Ondo State Judicial Service. And then in this Okafor and Nigerian Aviation Handling Company PLC is one that the court took a slightly different view because of the peculiar facts of the case. Now, the gentleman, Joseph Okafor, was employed as a senior legal officer. So his complaint was that in the course of his employment, that he was transferred to several departments, that they stagnated his career growth, and several other complaints. Now, some of the things, the series of events that occurred happened between 2009 and 2014. So in November 2015, the gentleman tendered his resignation and said that it will take effect in December 2015. He resigned, went to court, and said that he was constructively dismissed. So the court looked at the entire circumstances and said, you know what? One of the elements of constructive dismissal is that you ought to have resigned as soon as the event or the series of events that you are complaining of occurred. By the way, the actions that you are complaining of are not necessarily such that are serious enough to ground a claim for constructive dismissal. So I could go on and on about the cases, but I think the point has been made on the kind of actions that will be considered by the court to amount to constructive dismissal. Now, we all know what's going on. There's a pandemic. The world is turning on its head. The world of work is not even remain. It's no longer the same. Businesses are struggling to survive. In fact, as of yesterday, I think we were said to have about 8,915 cases and 259 deaths, which is a lot. I mean, compared to countries like US, but it is still a lot. When countries start reaching those kind of numbers, they start panicking. So in the workplace, it has substantially transformed the world of work and the nature that businesses are now running as well. But first of all, in a bid to survive the pandemic, employers have been trying to adopt some sort of innovative ideas and strategies to be able to cut costs or be able to stay afloat and survive the pandemic. But before I go further, one of the first important obligations of the employer in the context of COVID-19 is to ensure that the workplace is safe and healthy for the employees, especially if the employees are those that are required to come to work and be physically present in the office. I think if some of us have been following the news, we would have heard about the case in Oyo State where a particular, where about 149 employees have tested positive for coronavirus. So of course, the company has been shut down for now. In a particular company in Ghana, I'm not sure of the name, but what happened was that one employee, just one employee, was infected by the coronavirus, brought it to work, and then the company continued as usual, and 533 other employees became infected by the coronavirus. What does that say? What does that say? It says that employers have an obligation to ensure that the workplace is very safe for the employees to work in. So if the employer is not taking any step, and I see that the workplace is extremely dangerous and unhealthy and unsafe and toxic for me, and the employer still insists without making any measures to ensure that the workplace is safe, insists that I must come to work, the employee has the right to resign and then maintain an action for constructive dismissal, because the employer is making the workplace so difficult and toxic for the employee to the extent that the employee has no choice but to resign. What if there's a confirmed case in the workplace? In those cases, we've had some of those in Nigeria here, and I think the response of some of these companies has been quite commendable, because you just hear one of the notices that go off is that, oh, there was a confirmed case that visited our office, so the office has been shut down. We are decontaminating the entire office. All the employees have been asked to stay home and self-isolate for 14 days, and if possible, get tested. So in that kind of context, if there's a confirmed case in the workplace, like the Ghana and Oyo State, like I use that example, and everybody is aware, and you are trying to convince an employee or compel an employee to still come to work and work in that circumstance, the employee will have a right to resign, of course, and claim for constructive dismissal. As I said earlier, there are several options that are being considered, many of which possibly have already happened, especially in the context of unilateral variation of the terms of contract. What am I talking about? Salary reductions and change of employment status and all that. The position of the law now is that in changing the terms of employment of an employee, the employee must be engaged. That is what the court advises or encourages as social dialogue and participatory democracy, to ensure that the employees are carried along. Because as I said, the law now expects that the employer and the employee are now on what's seemingly equal footing to be able to negotiate the terms of their employment. It will seem I have been talking about the constructive dismissal and what employees, the rights of the employees. But then these cases, that the decisions of the court, these points that are being made are not necessarily to make the employer look bad or to send everybody to start challenging or fighting the employee, but they are actually being made to enable the employers know what to avoid, know what to do to be able to avoid constructive dismissal, and to desist from doing things that could also expose them to risks, that is such as employment-related risk or litigation. So one of the things that you have to do is to ensure that the work environment is respectful, free from bullying, toxicity, harassment, and hostility. In fact, a point that I need to make is that the conduct that leads to constructive dismissal does not necessarily need to come from the managing director or from the executive director or from a person in high places. It can even come from as low as maybe the line manager, the head of departments, or even fellow employees. So that's why the employer has an obligation to ensure that the workplace is peaceful, respectful, and that the dignity of the employee is maintained at all times. As I had highlighted before, and as we have seen from the case I've talked about, it is absolutely wrong to ask employees to resign. Employees already have a recognized right to resign. If they are going to resign, they are allowed to do so. But don't ask them, do not force them to resign. And then the law is settled that employers have the right to make certain changes to the employment contract. But if the changes that should be made to the employment contract is one that is fundamental, such as salary and all that, that the employee has to be engaged, the employee has to be involved. And then when you confirm this thing, it is also important to ensure that you have them in writing, so that when the situation arises, you can easily show that, look, this was a clear agreement by the parties. The variation between the parties of the employment contract was done in accordance with the employment contract and agreed to by the employee. Again, it's important to develop effective channels for communication and grievance management. Now, one of the interesting things about employment law litigation and employment law dispute is that sometimes it only takes one person. It only takes one person to go to court, one person to succeed in court, and then you will realize how many angry ex-employees you have. So in a particular case that I witnessed some time ago, one employee went to court and apparently a lot of people were watching. So because of the speed of National Industrial Court, about a year or 2 years or less than 2 years, the court delivered judgment in favor of the employee. Apparently, there were a lot of people who shared the same grievance in the company. What happened? 50 people went to court. So these are not the kind of exposure that you want. So what do? You ensure that there is a safe channel for effective communication and that grievances of employees are managed properly. Ensure that there's a safe environment for the employees to communicate, so that they can come to the employer or come to the HR person and express their fear, express their concerns, express the problems that they're having without being afraid that if I report what this person is doing,
all these top set of lawyers, then I
am going to suffer any effect. Then also, it's also important to look at employee complaints. So this is especially for the HR person. So from time to time, maybe quarterly, or biannually, or annually, look at the patterns of employee grievance. Maybe, I'm sure you can also look at this from exit interviews or organize anonymous feedback questionnaires or have a suggestion box. Look at the patterns that employees or the reason employees are starting to leave or the grievances that the employees have. So that way you can be able to nip it in the bud and manage it and stop it and change whatever it is that is happening before it gets out of hand. One thing you don't want is to have too many cases in your hand, because you want to avoid the reputational damage and the financial cost to you, especially if the employee succeeds. Even if the employee does not succeed, the money that you're going to spend in court, for example, if you're going to start appealing the judgment and all that, you're going to be spending a lot of money, which I believe would easily be avoided. Then the disciplinary procedure adopted by the employee has to be fair. The constitution of the panel has to be fair, and the employee should also be given an opportunity to be heard. So like I explained in the case of Ms. Okoye and Standard Alliance, when the court looked at the composition of the investigative committee, the court said, no, it is clear that this set of people are just ganging up against this lady. So the disciplinary procedure has to be fair so that the employee is not forced to resign even in the middle of the disciplinary procedure. Then, speaking of effective risk management mechanism, this is a way that you can be able to, now this, it can happen in two ways, either before the employee resigns or maybe after the employee resigns. Sometimes when the employee resigns, by conducting exit interviews, you can be able to understand why the employee has resigned. You can be able to manage whatever it is that is the grievance of the employee and even have the employee resolve the entire issue before it gets out of hand or even goes to court. So this is why it is also important to seek legal advice as often as necessary. I would always say this, the money you will spend in seeking the legal advice of a lawyer before court is most of the times less than what you will spend going to court. Because if you have like 20 employees sue you, all you would have needed is possibly one legal advice, one correct legal advice actually. So this is why it is important to ensure that you stay close to your lawyer, because your lawyer is someone that understands the evolution of employment law, the international best practices, and the standards that are expected from employers in the world of work. Finally, maintaining a comprehensive and up-to-date employee handbook is also very important, because the employee handbook and policies is what sets out all these procedures, all these risk management procedures, grievance management, communication procedures that will allow the employee also know what they should do, and other employees, even the management of the company, to know what they should do and what they should do right and what they should not do. So that, ladies and gentlemen, brings me to the end of the presentation. Thank you very much.
When I just joined and you're ending it. I mean,
Thank
is it my fault that
Nonso, please. We did not beg you to come 42 minutes late. Thank you so very much. Chisom, absolutely, absolutely lovely presentation. We will open up for questions, but to manage the flow, I would ask that you please drop your questions in the chat box. We already have a couple of questions, which I will then proceed to share with you, Nonso, so that Chisom, so that you can respond to them. Sure. So the first question we have is, what if an employee is advised to resign as a saving measure or help for the employee, that is to avoid termination? What do you say to such employees?
Okay.
Will that then be constructive dismissal?
Yes, it would be constructive dismissal. As I mentioned in the case of Ashana and First Bank, that was actually what happened. The employee was advised to resign, or the other alternative would have been to terminate the employment. So what the law now states is, look, if you want to end the relationship, end it in accordance with the clear terms of the employment contract. If you force the employee, if you as much as force the employee to resign or ask the employee to resign, the employee can come around, because as at the time you're telling the employee to resign, the employee probably has no idea what's going on. In fact, in Ashana and First Bank, what had happened was that the defendants even alleged that the reason they told her to resign is because of her poor performance, and that the other alternative would have been to terminate the employment. But the court held that as long as her resignation was involuntary, or that she was forced to resign or asked to resign, as the case may be, that she can maintain an action. And as I said earlier, resignation is a right of the employee. The employee can resign at any time. As at the time we're having the conversation, I can resign, and it is my right to do so. And you cannot even reject my resignation. So I think it is a matter of having employees understand their rights, especially including their right to resign. So that you don't put yourself in a position where the employee can turn around on you one day and then sue you for constructive dismissal. And if the facts of the case are such that reveals constructive dismissal, definitely you'll probably be exposed to damages.
Okay. If an employee is advised to resign due to restructuring, is that also constructive dismissal?
Yeah, absolutely. In fact, that is what happened in Keystone Bank, Lawson and Keystone Bank, and also in Lawson and Keystone Bank. That's what happened. There was a restructuring. I think Sky Bank was which bank was that? Was it Bank PHP? Was being changed to Keystone Bank, and it was in the core course of a restructure. So the employee was called and told. In fact, it was a standard practice. The bank that at any time that the bank wants to carry out a redundancy, it will tell the employees to resign. So if it's in the form of a redundancy or a restructuring and you ask the employees to resign, then definitely the employee can turn around. Now, the very good thing about it is that there are decided cases for most of these situations. Unfortunately, we are not sure we have cases that reflect the situations that will arise as a result of COVID-19, which is something that will most likely happen in due course. But then these are the things that will happen, these are the things that the court will look at and say, the forced resignation amounts to constructive dismissal.
Okay, Thank you. So what happens if the employer claims redundancy?
If the employer claims redundancy, then it has to follow the position of, if the employment contract provides for the procedures or benefits or payments or steps that should be complied with in the process of or rather in the occurrence of a redundancy, then that should also be followed. And then we should not also forget the provisions of Section 20 of the Labor Act, which sets out the obligations of an employer in the event of a redundancy. So redundancy, you have to ensure that you do it in accordance with the provision of the law and the terms of the employment contract. In fact, it was in one of the cases that I discussed where the company was trying to declare some employees redundant and instead decided to ask them to resign, which led to the employees claiming an action for constructive dismissal.
Okay, so this isn't exactly on all fours with your presentation, but it's a question we've received, so I hope you'll indulge there.
Okay.
So the question is, when an employee resigns during a disciplinary procedure, should a resignation be accepted and all benefits like long service benefit be paid? Can you reject the resignation? Can you compulsorily mandate the employee to face the panel after the resignation?
Absolutely not. You cannot, if the employee tenders the resignation in the middle of the disciplinary proceedings, the employee has the right to walk away. You don't even have the right to reject a resignation. The employee's resignation, there are a series of cases where the court has held that the resignation of an employee is final. But the law has also put in place, and there are some cases to that effect, that there may be certain consequences for resignation with immediate effect. For example, an employee that resigns with immediate effect, for instance, to avoid these disciplinary proceedings. And of course, it depends on the fact of each case. The position of the law is that the employee forfeits certain benefits. Of course, this would depend on the facts and circumstances of each case and also the terms of the employment contract. But the standard position of the court is that the employee has the right to resign. The resignation cannot even be rejected. And if the employee resigns with immediate effect, the employee forfeits certain benefits. And again, mind you that some employment contract also provides that if the employee terminates the employment contract without notice, the employee will be obligated to pay certain salaries in lieu of notice. I mean, it's not something that I have seen very much that has been enforced by the employer, but it is always stated in the contract. So that is usually the consequence.
So that's actually, for me, the last of the questions we have. This has been a very...
hands raised on the chat. Okoye is one of them.
Oh, I haven't seen this raised hands. Okay, well, okay, so I have another question for you. Well, before we take this question, I think Mr. Kuti has a question for you, right?
I believe so. He has his hands raised, so I'll just unmute him.
Okay.
Hello. Hello.
Hello.
Hey.
Hi, Mary. Good evening. Jay. Good evening.
I'm very happy to have you, Ron.
I'm very, very happy, delighted to be part of this. Well, not so much of a question, except to chip in and commend Chisom. It went the extra mile. At some point, I actually wanted to call him to say, Chisom, when you make a presentation like this, you should reserve some for clients to come and ask and pay. You let down everything out of the bag. Everything. But please, I must say thank you. Beautiful presentation. Well done. Exhausted the issue about constructive dismissal. Perhaps if I can, not departing from what he has said about when the employer asks you to resign. What do you construe that? Indeed, what has happened in the whole dispensation is that in some sectors, very sensitive sectors like the financial sectors, where a termination or a dismissal is likely to be construed as one impugning on the integrity of the employee, and as such, is very, very unlikely to get engaged in any other, by any other bank or just about any other business within that particular sector. What used to happen is that you have a situation where the handbook would envisage that and then make a provision that at some point, depending on the state of play or the fact pattern, the employee might probably be asked to resign. And of course, with full benefits and all of that. So that used to be the position until the new dispensation and one or two cases, one of them, I think he cited very correctly, well, there, started with the fact that to even suggest to anybody to resign will be termed constructive disengagement. So that's where all of that started from. So the advice, I mean, like Riley pointed out, is it shouldn't even be on the table. The employer should remove it from his handbook and should not even bring it forward to advise as to whether you want to resign and all of that, just to protect your image to his prospect of some other engagement within the same sector. Because unfortunately, this is what labor within the context of international best practices are decided to term it. That the moment we're in a relationship and I suggest to you that you walk away, I'm constructively disengaging you. Again, I have not said anything different from what Chisom has said. Brilliantly well expounded. Thank you so much, Chisom.
Thank you very much.
Extremely proud to have been part of this. Thank you. That's all.
So Chisom,
Hello,
some
Mary.
more questions have come in.
I think
so I'm going
Benga
to
has a question. He's raising
raise
his hand.
those
I don't know if
again.
you want to...
So the first question we have is,
Okay.
how practicable are these rights in a sole proprietor's law firm, as the employment term are mostly not structured? So do you have an answer?
I think it's a right to sue for constructive dismissal is a right that every employee has. But then I would understand the context of the question that the person was asking, because I mean, one of the fears is that if you're a lawyer and you sue your employer, it might be a bit difficult for you to even get your job, get a job somewhere else. But then again, there is also nothing stopping you from enforcing your rights. The practicality of these rights, it is very, very possible. All you just have to do is ensure that it complies with the elements of constructive dismissal as laid down by the law, and then you can always enforce your rights. In fact, the main idea behind the concept of constructive dismissal is that, one, the employee is entitled to dignity of human person, and that every workplace should have mutual trust and confidence, and this should not be eroded. And when this is eroded, thereby forcing the employee to resign, the employee has a right to resign and institute an action for constructive dismissal. And depending on the facts of the case and the ability to prove the case very well before the court, they can succeed. But then I would understand the fear of some sort of, I hear some people talk about the fear that if you sue one employer, there is a possibility that you might not get another job. But then I think some of the people who have sued are working somewhere else now. So it's neither here nor there.
Hello, Mary. You want to take more questions?
I think Benga Bello wants to speak, please.
Yes, Benga wants to speak. I think we may have lost Mary, but let me use the advantage of the technical person to ask a question before we unmute Benga Bello and the others. So, I mean, I don't need to tell you again how awesome the presentation is. Very well done, thank you. My question is on one of the issues you touched on in your presentation, which is a very, very contemporary issue right now in view of the pandemic. And that is with regards to the right of employers to unilaterally vary the terms of the employment contract. So what we've seen happen a lot is that many businesses, because of the dwindling revenue and restrictions on businesses based on government directives, have resorted to reducing salaries, forcing people to go on compulsory leave, some canceling bonuses, and doing all sorts just in a bid to keep the business afloat.
Mm-hmm.
There have been different opinions sharply between the employers, HR departments, and of course, employment lawyers on whether this is right or wrong. What you said in your presentation is a unilateral reduction in salaries is constructive dismissal. I think you cited the case. But would the present circumstances we have, the pandemic and the effect on businesses, have any bearing on what I assume is the general principle of law? How do you predict the courts would approach this situation in the coming months?
Well, unfortunately, the context of this COVID-19 is not one that has been tested in court right now. I mean, maybe sometime in the future, but I can quickly lead you to a case that I mentioned in the course of my presentation, where the court had actually looked at a similar situation. In fact, the reason for the reduction was as a result of economic downturn. Nigeria was in recession at the time. So the employment contract clearly stated that any variation of the employment contract should be agreed by the parties and in writing. So the employer reduced salaries, and then the employee worked for a couple of months based on the reduced salary, 50% salary, and then decided that he could not take it anymore and went to court. The position of the court held on the basis on the forefront that the unilateral variation of the employment contract by the employer without engaging the employee amounts to a breach of contract. But because of the circumstances of that case, the employee had actually accepted the variation of the contract and worked for a couple of months. So the court was of the view that because the employee accepted it, continued to work, and then decided to resign a long time along the line and come into court, that the employee was deemed to have waived his right to challenge that variation. So in that particular case, Oyemi and Guardian Global Resources Limited, what the court held was that the court adopted a Canadian case, which I mentioned earlier, and said that where there is a unilateral variation, it does not immediately amount to constructive dismissal. It is the actions that follow. Where there is a unilateral variation of the employment contract, the employee has three choices. He can either reject it, resign, and sue, or accept it, or reject it, protest, and then continue to work, and then maybe see if things change in the future. So, for example, the case of, I think, modeling that I mentioned earlier, where the employer was supposed to review his position upon completion of his probationary period. At the end of the 6 months, the employer did not review that his position. In fact, he continued to work for 20 months, but he continued to protest until he decided that he could not take it anymore. So I cannot particularly determine how the courts would decide it, but one thing I can tell you is that the National Industrial Court works with what you would call the primacy of facts, and it will determine each case based on the specific facts and circumstances surrounding it. So it is not the express resignation and just going to court that will permit you or grant you judgment in your favor or for constructive dismissal. So the court will have to look at the cases individually, the circumstances that led to the resignation, and the actions of the employer to be sure that it was sufficiently serious for the employee to resign and sue for constructive dismissal.
Thank you very much. So we have a few hands raised. Benga Bello has his hands raised, so I'll take him before I come to Frank. Benga, you have the floor.
Thank you very much, Chisom. This could not be more brilliant than what it is. It's an attestation to the good works in Pechton and Gribbs, which I am a proud alumnus. Fantastic presentation, brilliant, brilliant. My question, I'm going to try to weave it up so that I'm not asking 3 questions. Okay, so in the constituents of what may constitute constructive dismissal, you have highlighted certain points, part of which is that where mutual trust and confidence is broken, as a line that could be drawn, that any act of resignation by the employee is constituted or could constitute constructive dismissal. I will put a story around this. Okay. Assuming there's a director in a company, a director properly so called, say a CEO, who by the nature of the karma, which gives, which states that directors must enjoy the confidence and the trust of the board. And it appears that from the actions of the director, there are reasons, either by reason of skill, carelessness, negligence, the board has stopped to enjoy his confidence or trust. And indeed, something had happened in which that director had given an instruction to a lower cadre of employee. And the employee took the matter to the board or writes an email to a member of the board that this may not be a legal thing I should do, even though it's an instruction from my CEO. I don't think, and the member of the board says, do not, hold off, don't do it. Let us have a discussion with the director, right? Now, this director did not issue a query to the employee. Rather, in the discussions with the board and when the board was trying to take a commercial decision or a strategic decision, the CEO became very furious and, he resigned. He sued and says that, look, I do not enjoy the trust and confidence of this. In fact, the relationships are broken and it is becoming hostile for me, even though there is no breach. There is nothing to show a breach in terms of demotion, in terms of anything. So the question is this: in such a situation, is a breach by the employer not sacrosanct to trying to force a constructive dismissal, knowing full well that to enjoy the trust of a director in a company is provided by law? So if that trust and confidence is not there and the employee now goes to court to say, I don't enjoy the trust, is it enough without breach of the terms and conditions? Thank you.
Thank you very much, Beg. I try to follow your question line. In fact, before you even ask the question, I remember one of the sessions we had at Ellen, and I am sure it was going to be an interesting question. So this breach of mutual trust and confidence is not just a simple, I don't like what this person is doing. It's not a simple, I am just merely unhappy with what A has done or merely unhappy with what B has done. Like I said, the conduct of the employer has to be sufficiently serious. It has to be one, even though it might not be a breach of the clear terms of the employment contract, but the conduct of the employer has to be sufficiently serious or grave enough to force the employee to resign. So a mere resignation, like I mentioned in one of the cases, Okafo and Nigerian Aviation Handling Company, where he complained of a couple of things, that he was being frustrated and his career was being stagnated and was being transferred to a different department. When the court looked at the specific facts of the case, one of the things that the court said was that the things you are complaining about are not sufficiently serious for to ground an action for constructive dismissal. So like I said in the course of my presentation, the court looks at the specific facts of each case to be able to determine if the conduct of the employer is enough to force the employee to resign. But if it is not that serious, if it is something that is just a mere, what's the word should I use now? A mere feeling of the employee that is not serious enough for the employee to resign, the court might not grant damages or even permit the employee to allow the employee to succeed in that action against the employer. I hope that answers your question.
Thank you. Frank, you had a question. Do you want to share a question with us now? You have your hand raised. Frank, are you still on the call? Okay. Well, while we're waiting for Frank, we have a question here. And the question is, employment contract is still a contract and subject to the law of contract. The pandemic presents a situation of possible force majeure doctrine of, oh, well, this is just a comment. So we have a question.
Frank is unmuted now.
Okay, all right.
Okay, so thank you so much. Hello.
Yeah, we can hear you. Go ahead.
Yes, please go on.
Okay, so thank you, Chisom, for a brilliant presentation. Mine is a straight question. We have seen cases where people have displayed acts of dishonesty and the benefits like long-term service, end of service payout, that runs into millions, and they know that because of acts of dishonesty that they've been involved in, when they go through the DC process and they are dismissed, they may miss out on such benefits. And so what they quickly do to evade justice, as it were, is to do immediate resignation. In the course of your presentation, you said you cannot reject a resignation. And so if the organization then decides to accept the resignation, it's more like a case of people eating their cake and having it. They displayed a dismissible act. Would the organization just accept such resignations and then they get all of the benefits that they are also supposed to? So I need you to shed some light on this. I also know that you said when people drop immediate resignation, they lose out on certain benefits. I also want you to shed light on such benefits. Thank you.
Okay. I may not be able to speak to every single benefit that this will affect, but then the courts have held that if an employee resigned with immediate effect, especially in cases like this in the middle of a disciplinary proceedings, what the employee has done is to forfeit certain benefits. And when I say certain benefits, there are certain benefits that obviously you cannot deny the employee, such as benefits that have accrued over time, such as pension. You cannot say because you resign that I will not remit your pensions. There are some terminal benefits that will continue to remain even if the employee resigns in the middle of a disciplinary process. But there are certain other benefits which, if the employee resigns, and it is one that the employee would have been entitled to if the resignation was a clear resignation that was not biased or informed by the disciplinary proceedings, the position of the courts is that the employee forfeits those benefits. So it will depend on the terms of the contract, and that is why in the course of my presentation, I mentioned that it is important to have the employment contract, the employee handbook and the employment contracts clearly explain these things and also regulate this action so that where an employee, the employment handbook will state clearly that if the employee resigns in the middle of a disciplinary proceeding or in certain circumstances, that this will be the implication. Now, in one or two cases, the position of the court is that the employer cannot be able to sanction the employee for certain things if it is not provided in the employee handbook, which is why, as I said, it is now important for every employer to go back, look at their employment handbook and ensure that it covers this variety of situations that arise in the workplace.
Thank you, Chisom. So we have another question. I would like to know your take on Section 7.2 of the Labor Act, which seems to give the employer the right to to unilaterally vary the terms of the employment contract and merely inform the worker. Would a unilateral variation of terms of employment contract based on that section ground a claim for constructive dismissal?
Okay.
I'm going to try and see if I can pull up the section so that I can read it out for our benefit later on.
Oh, do you want to do that now, or should I go on?
Yeah, I'm doing that now. I have actually.
Okay, that's fine.
So I'm just going to read it out.
If you know the section, you could proceed with the question. Answer.
Okay.
I think.
Okay, so yeah, by the question, I think I can proceed. I think the starting point is to understand that the Labor Act does not necessarily apply to every cadre of employees. That is one. Then two is that the courts have recognized that it is not in every situation that the employer needs to engage the employee to vary certain terms. So for example, in the employment contract or the employee handbook, certain operational or administrative provisions of the terms of the contract can easily be amended by the employer. But if the amendment is such, and this has been held by the court, that if the amendment is such that affects a fundamental term of the contract, such as the pecuniary or economic benefits of the employee has to be engaged. The employee has to be taken into confidence. Yes, even though the Section 72 of the Labor Act provides this, as I said, first of all, it doesn't apply to every cadre of employees. And second, the court has, by its decisions and by the third alteration of the 1999 Constitution, moved away from a lot of provisions of this nature that give the employer the free hand to vary fundamental terms of the employment contract. Also, the ILO now encourages what we know as participatory democracy and social dialogue, and also encourages employers to always ensure that the employees are involved and engaged before the variation of fundamental or material terms of their employment contracts. So Section 72 of the Labor Act is not all-encompassing, so to speak.
All right, thank you. I actually have seen the section, and I think I should provide some context because the law actually sort of suggests where Chisom has landed. It says, if after the dates to which the statement relates, there is a change in the terms to be included or referred to in the statement, you shall notify the nature of a change by a written statement. This sort of suggests, I mean, and this is my opinion anyway, that it is a change, something you were meant to have said, but you didn't quite say it. So I don't think that it suggests that there is, I'm varying a term we have already agreed, because that will actually destroy, as we know it, the principles of contract. Nonso has his hand up. So Nonso, you have the floor.
Hello, everyone. Good evening. Chisom, thanks for a brilliant presentation. I just want to present a scenario. An employee had actually been issued, a termination letter, and he now approached.
No, sir, you're not audible, please.
Can you hear me now, please? Sorry. Hello.
It's still distant.
Oh, sorry. I'm actually on the road. Hello, can you hear me now?
Yes, I can hear you.
That's your question. I can hear you.
Oh, okay, good. Jamie said he wasn't hearing me. Okay. How do we react to a situation whereby an employee had been issued a termination letter for non-performance, so to speak? Then he approaches the management or the human resource person and said, please, can you transmute this or reduce it? Okay, can you give me the option to resign? And the condition was, okay, since you want us to allow you to resign, you will pay us 1 month's salary in lieu, and you can now resign. So he wrote a check, gave to the company, and now tendered his resignation. Can we, under any guise, under any imagination, see anything improper in the circumstance, given that he had actually been terminated effectively, but he approached the management and sought, to change it so that he would not have the option of resignation. How do you approach such scenario?
I mean, I would understand the employer trying to accept that kind of arrangement, but it is not especially an arrangement that I would advise, because I mean, there are one or two risks that are involved. I don't think it is a good look for an employee to say that I was terminated and then I asked the company to convert it to a resignation, and then I resigned and I gave the company a check. It is not a very good look. I mean, it may work in some cases where the employee is acting in good faith and you may get away with it, but it is not something that I personally would really advise, because you've terminated the employment, and you terminated it, especially if you did so in accordance with the terms of the employment contract. Going back again to now change it to a resignation, it presents a bit of a risk to me. At least that is my view. It presents a bit of a risk that I would advise that one should be very careful about. Because if it turns around and the employee in the future turns around to say, look, they asked me to resign, and in the discussion with them, they told me to resign. I even issued them a check and they accepted it. They told me that the condition of my resignation in an alternative to being terminated, or my termination continuing to stand, is that I should resign and give them a check. It's not a very, very good look. I would understand that the idea is perhaps to give the employee an opportunity to seek future jobs and everything, but I wouldn't really advise it. Sometimes people get away with it, but it's one that employers should be very careful about. That's why all these things should be carefully codified in the employment contract or the employee handbook, so that people will know what to do or the steps to take in every circumstances.
So Chisom, just flowing on those questions before I go to the next question we have. Would you change your position if what has happened is that the employer is saying to the employee, yes, I will accept this resignation, but I will document it in your file that we had terminated your appointment. You wanted us to commute it. And because we're willing to let you go on a clean file, you're commuting it and you're going to sign that document. Yeah, you file a resignation, but you sign this document for me. Will that change? Yes. Will that change your position?
It's something before you answer, Mary. Okay. Sorry, Chisom. I want to chip in something on that. It's very, very interesting angle that Mary is trying to stir up now. Yes. Because the point is this: if I had served you a termination letter, factually, what really happened that when the guy sought for you to be committed to allow him to resign, the termination letter was withdrawn, because it becomes a factual issue now. So what is the effect? Protecting the company, I could say, I could advise what Mary is saying, but what if the guy succeeded in asking them to take back the termination letter? Does it take effect upon being served, even when you withdraw it subsequently? No, these are the nuances that you have to look around, the facts surrounding it.
Yeah, so what I have seen in certain cases, there are certain employment contracts that provide for appeal procedures. So if you look at some employee handbook, it provides that where the employment is terminated, the employee has the right to appeal the termination. If in the course of the appeal, the employer looks at it and says, okay, fine, we can change this. Like I said earlier, it is a bit of a risk, but also it is one that one should also be diligent about or be careful about, because I've seen some people do it. So what they do is they decide they withdraw the letter of termination, the employee resigns, and then maybe what they do is they sign a form of mutual settlement and release. But so that in the event in the future that the employee goes to court, they can easily bring out that document and the court can easily see that this was a term that was agreed by the parties and both parties actually agreed to go their separate ways. It is not something that I have seen has been tested out in court, but I know that it is something that some people do. But again, it's neither here nor there. It's one to still be very careful about.
Okay. We have another question. I have actually, Okoye has his hand raised up. So, Okoye, do you want to take your question? I mean, you had typed your question, but do you want to ask it yourself? All right. Okay, do you have another question?
No,
okay,
I don't. Yes, I don't have any other question. The question has already been answered. Thank you.
Okay, all right. So a question we have is where an employee resigns based on constructive dismissal, but the terminal benefits have been calculated by the employer and paid to the employee. Can the employee still complain or claim for constructive dismissal?
Absolutely. Absolutely. The employee can. So if you look at the couple of cases that the employer has sued for constructive dismissal, the National Industrial Court, by virtue of, I think, Section 19D of the National Industrial Court Act, has the right to award compensation and damages in deserving circumstances. So if you look at the series of cases and the patterns of the court awards separate damages for the constructive dismissal and then still goes ahead to order that the employees' benefits and benefits and damages and all other entitlements should be paid to the employee. Although what some employers do is that at the point of the resignation, they get a statement from the employee admitting that they have paid the entitlement and the employee has no claim against the company, or the employee has no grievance against the company. Sometimes that may not work absolutely, but then there has been a case where the employee, at the point of resignation, the employer went ahead to pay him his terminal benefits. He accepted it, but he accepted it under protest. And when he went to the court, the employer tried to say that I have paid him his benefits. The court said, look, he accepted it, but he accepted it under protest. So you cannot say that he has waived his right to complain. He still has a right to complain and go to court, and he's entitled to damages. But the payment of entitlements or terminal benefits is different from compensation for constructive dismissal. But whereby the conduct of the employee, one way or another, or maybe by a document that was executed by the employee without duress, it can be shown that the employee voluntarily waived all those rights and stated that I don't have any grievance against the company or anything of that nature. Then I don't believe that the employee will succeed in an action against the company. But the important point is that payment of terminal benefits alone does not sweep away the right to sue for constructive dismissal.
Okay. I have a question, and after this question, we'll take Nina's question. So what happens if an employer engages the employee in order to vary the terms of the employment and the employee does not agree to the variation and the employee subsequently resigns following the variation? Is that still constructive dismissal?
No, I wouldn't think so, because if the employee had gone forward to engage the employee and it was in the course of the discussion that the employee resigned, then the employer cannot be said to have taken any step that amounted to the constructive dismissal. It is still, especially if the approach by the employer was, look, let us discuss. This is the situation. I'd like to hear from you. But it is different from a situation where the employer goes ahead to implement a unilateral variation of the employment contract, and the employee says, look, I cannot take this unilateral variation, and resigns. But if it is in the course of a discussion and the employer is trying to engage the employee and the employee resigns and goes to sue, then I do not think that they will succeed in an action for constructive dismissal.
Okay, thank you. Nina, you have the floor. And after Nina, I think we have Mr. Kuti, and that will be a wrap for this session. Nina.
Hello.
Nina. Hello, Nina, we can hear you.
Okay, if we can't hear her, then Mr. Kuti. I know Mr. Kuti has his hand raised. Okay, finally, we can hear you, Nina, yeah?
All right, thank you very much, Mary. Good evening, everyone. Thank you, Mary, for your brilliant moderation. And Chisom, thank you for that fantastic delivery. Very educative indeed. Thank you. And also to all the participants at today's webinar, thank you for attending. So before I ask the question, if I could just make a comment on Nonso's earlier question, I would think it would be very dangerous for an employer to issue a termination letter, decide to withdraw it or maybe put it on file, and subsequently accept a resignation letter from the because that would just be trying to approbate and reprobate. And if I were representing the employee, there's nothing you're going to say about that termination letter that's going to fly, because you cannot be saying there's a termination and a resignation at the same time. So I think the simple thing would be to assume that the later arrangement will supersede the former, in which case, if you have accepted the resignation, so there's no termination on ground already, you could have the terms upon which that resignation was accepted. So I think it would be very risky for an employer to try to toe that line, just my opinion. Then I have a question, and I want to ask this question from an employer's perspective. So we know that in the country we live in, it's not a fantastic thing to have a termination on record, you know, to have on an employee's file, for example, that this person was terminated from this employment. And I'm going to use a case I'm aware of. This is a live story that happened to somebody I happen to know. So assuming you have an employee, for example, who is underperforming, sleeps on the job, is not very useful, but you know that this person actually has the capacity to succeed in life, you know, so you don't want to dent that person's record, and you just have a conversation, maybe 2 years on the road, appraisals, the person is underperforming, and you just advise the person, you know, you could just take the door and leave this establishment because maybe your career is not here. And the employee decides to honor that request, resign, and subsequently sue for constructive dismissal. What would be the employer's defense in that case? The second scenario is an employee who is fraudulent, has defrauded the company in the millions, and the company is aware, but of course it doesn't want to get into the murky waters of having a disciplinary hearing and having that risk of being accused of conducting a criminal quasi-trial in company. So at the end of the day, it's without a trial, without a hearing, everybody knows that this person's hands are dirty, and maybe management just calls the person aside and says, oh boy, we can't continue with you here because you're really milking us dry. We will advise you to just submit your resignation letter, just go peacefully, we'll pay you your benefits. And the employee decides to tender a resignation. If the employee brings up an action for constructive dismissal in this case, will it be a defense for the employer to say, oh, this person was actually found to be fraudulent, and that's the reason why we advised him to resign, because we didn't want to, stain his records, so we didn't want to be unnice to him? Would the court, how do you think the court will react to that? And in the other person's case as well, oh, we know this person is a star student, has had a brilliant career somewhere else, but maybe our organization doesn't fit. And even though we know we could have terminated and paid terminal benefits, we didn't just want to have it on record that we let the person go. We wanted to give the person the dignity of saying that he decided to walk out of the door. So are there any defenses an employer can actually put up in these instances? In your experience, have you seen any, and what are your thoughts? Thank you.
So I think some of these things, my outright comment would be that the reaction of the courts might be that this defense of the company is probably an afterthought. So what some employers do is that they have a properly laid down procedure with regards to employees whose performance is so poor that they cannot continue to retain the employee. So if you have that procedure laid down, I will never tell you to advise an employee to resign. That is what happened in National and First Bank. The defendant claimed that the reason that they asked her to resign is that her performance was very poor. And still, the court held that it was constructive dismissal to have forced her to resign. So yes, you might think you are doing her a favor. Even, I think, like Mr. Kuti said when he came in, it was something that back in the day, it used to be deemed as some form of favor on the part of the employee, like you were helping the employee by asking them to resign as opposed to having a termination. So if you have a laid down procedure, maybe you have some form of recovery process to see if the employer, that will give the employee an opportunity to redeem themselves, and the employee will know that if repeatedly, or if after 1, 2, 3 steps, the performance of the employee is not satisfactory, this is the step that the employer will take, that the employer will have no choice but to let you go. I think any wise employee who knows their rights, especially in terms of resignation, every employee should know that resignation is a right that they have. But it is not an option that the employer should ask the employee to take, even if the employer is trying to do the employee a favor. Because as we have seen in a couple of cases, the outcome is always that the employee turns around and sues for constructive dismissal. That tends to happen a lot. So what I would advise is have a documented process for poor performance, so that when these step-by-step procedures are being taken and is leading to a form of unfortunate end, if the employee is wise, what he would do or what she would do is to simply tender their resignation and leave. Then if it is getting to that stage, perhaps what you can do is to hint at the employee that, look, if by this last stage you do not fulfill your obligations to the satisfaction of the employee, the employer will have no choice but to terminate your employment. Now, when you let them know this consequence, there's a way you can slightly hint at the consequence that will happen at the end of that stage without asking the employee to resign. And if the employee is wise, what will most likely happen is that they will put in their resignation and leave. But I will not ask you to tell an employee to resign, even if the employee is performing poorly and you want to call them aside and tell them. The thing that will happen is that if the employee is aggrieved, one of the first things they will do is to tender the resignation. Now, in a couple of cases that I have even seen, what you see is that, like this National First Bank, what the lady did is that she went back, wrote her resignation letter and said, further to my meeting with the management of the company where I was asked to resign, I hereby tender my resignation, full stop. And then she went to court, tendered that document and succeeded. So those are not risks that you want to take or you want to expose yourself to. But there are also ways that you can carefully manage the situation so that the employee will know the consequence that is coming. And then if he's wise, he can take the better step to resign. If not, then the employer will have no choice but to terminate the employment. Then on the second question of conduct of a criminal nature, I think the law is settled that the employer, even if the misconduct of the employee is of a criminal nature, the employer still has the right to give the employee fair hearing, conduct disciplinary proceedings, and dismiss or terminate the employment if it so pleases, if it is dissatisfied with the response of the employee. So it is always important to ensure that you can always carry out the disciplinary proceedings. It is better to do it than to say that you don't want to go through. You're not going to be carrying out judicial proceedings if you give the employee, if you conduct a disciplinary hearing in respect of an employee that is maybe culpable for a conduct of a criminal nature. The law permits you to conduct disciplinary hearing in respect of that employee if the response of the employee is not satisfactory, or if the employee is found to have committed the said misconduct, the employer is allowed to dismiss or terminate the employment. Don't wait. Don't ask the employee to resign and then come later in the course of the defense and say, this is why we asked. The court will not accept it. The court will say, as far as the documents and the facts before me are concerned, this is constructive dismissal, and the excuse of criminal misconduct or whatever is an afterthought. So it is unlikely that the court will accept that kind of excuse. So it is better to always ensure that you comply with the terms of the employment contract by the letter. It saves you so much more risk, so much more stress, and so much more reputational damage than you'll be exposed if you don't do it right. Thank you.
Okay. So Mr. Kuti has his hand raised, so we'll take his question, and actually that's the last question we can take because we've exceeded our time limit. Mr. Kuti?
Hello?
Hello, Mr. Kuti, yes, you have the floor.
Oh, fantastic, Mary. Thank you very much. I've been waiting.
I am so sorry.
Last three interventions, Inina asked great questions. Chisom went around it beautifully well, but I'll just chip one or two things. You know, the interesting thing about constructive dismissal. Constructive dismissal is a raging issue in the new dispensation because of what ILO, not even what 254 of the Constitution has stipulated. ILO has come up with a number of conventions, standard recommendations as to what happens in the world of work. And irrespective of what you sign, it's not so much about the contract or parties. Irrespective of what you sign, what can be easily termed as forced labor. And that is the reason why ILO Convention recognizes that, look, termination and resignation can be so closely related, but they are mutually exclusive. I am entitled to follow, let's just follow this. Employer is entitled to insist, employer must follow through the provision of the contract in terminating. Employee can walk away without following through. And how do I mean? Termination must be strictly in accordance with giving 1 month, 3 months, whatever you agree with, or salary in lieu. When the employee decides to bring it to an end, you can simply decide in the middle of disciplinary infraction, decide to walk away. And when he decides to walk away, you cannot do anything about it. He must go. So in context, let's bring to context of constructive dismissal. It is not advisable for any organization to have in their handbook that for certain reasons, an employee can be asked to resign. Maybe under the old dispensation, not anymore. There are a couple of cases that if you had time, we'll be able to demonstrate that, look, that is not going to favor any employer anymore. And I think Chisom beautifully summed it all up when he was trying to analyze case law and the scenario. Now, the question has been asked. For some reason, you want to give him maybe some sort of, rather than terminate or expressly say you are dismissing, a questioning effect that resign. The law now is that to suggest to the employee to resign is constructively disengaging him. Constructive dismissal in the old days, in the old dispensation, was strictly analyzed along the line of making the work environment uncomfortable or making it pretty uncomfortable for the employee to achieve the set target at work. And now it's been extended by ILO standard to be, even when you suggest such things and all of that. So the question now comes, what is the best thing when you're faced with such things and all of that? Do you look at your handbook? At every point in time, employer must recognize when it is time to end the relations in the world of work, you must follow strictly the handbook. That is, you must follow strictly, not necessarily the handbook anymore, ILO convention that you must either give a notice or pay salary in lieu. But when it is time for the man to walk away, the employee is, even when he's been investigated for, he can walk away. So the only thing is that it loses benefit ordinarily he would have gotten and all of that. So it's a delicate balance. And at the end of the day, contract of employment, just like contracts generally, it's almost like we're drawing a convenient wedge, a convenient balance between opposing interests. And I use that advisedly. Opposing interests is that, yes, we both laugh, we shake hands and all of that. But the truth in itself is that when we sit in a contract, we want to protect our interests. So our interests are mutually exclusive and they're almost not aligning. So because they're not aligning, you want to look at, in the event of dispute resolution, if it goes to court, what is the court going to say about it? The court would interpret anything that seems to suggest, employer suggesting to the employee that, look, do this so that I can let you go and I'll pay you this and undo whatever. You can easily construe it as constructive dismissal. And meanwhile, we keep talking about constructive dismissal without looking at the grim prospects of the attendant damages that follow. I've been involved in a couple of cases I would not want to mention that attendant damages that follow this, oh, why should you do this and all of that? Then we must apply exemplary damages so that other employers don't do this. So those are some of the things that you need to look at. And the takeaway for me is not so much about talking about it like an academic topic. It is looking at the handbook. And I mentioned it when we're discussing this before now. I said, look at the handbooks of banks, employers involved in the financial sector, there's a provision there that allows this. But that provision, unfortunately, when it comes to the industrial court, just like the way it was done in the one that said when a man is being investigated, his resignation will not be treated. And the industrial court says, no. That is what they call the Unity Banks clause. His investigation and all that, irrespective, the moment he tenders his resignation, allow him to go, otherwise it's a forced labor. So you need to start thinking along the context of, look, how do you protect as an employer? This is not necessarily constructive dismissal literature. Protecting that when it comes in the context of legal issues and dispute resolution in court, how is the employer covered? That's all the man that had so much issue and he said I had to let go and all that. And I remember I advised even a finance bank, a bank the other day, and the guy had to come begging that rather than, can you just commute my termination to resignation? We said, okay, if you can put all of that, as opposed to this is all suggesting it to him. So there are quite a number of things you need to think through and watch out for and guard against when you're advising. I mean, for me, that is the whole philosophy around the new dispensation of law in constructive dismissal. What are we looking out for so that it doesn't turn around what ordinarily would have thought was to be a favor, and then it opens the employer open up to attendant damages that ordinarily should not have been, and all that. Thank you. That's my intervention.
Thanks a lot. I was actually going to end this, but we do have a question from Tabitha Jupure. So, and this is Tabitha's first time. Tabitha is our guest. So, Tabitha, you have the floor.
Okay. Thank you very much, everybody. Chisom, I joined pretty late during the Q&A section. So I have a real life case scenario that I'd like to ask. Okay, so can you hear me?
Yes, we can. Go ahead.
Okay. So I had a colleague who was sent an email of about 8 colleagues to have a meeting with the CEO or MD. So because the particular colleague was walked out of office that particular day, so the colleague later heard that they were offered termination letter on the spot. That's those that attended the meeting. They were all offered termination letter on the spot. And then on hearing this, the colleague sent a resignation the next day because she doesn't want to collect a termination. So could this fall under constructive dismissal? So the company's ground now is that the company is no longer capable to pay staff, so to say. So can this kind of resignation fall under constructive dismissal?
Chisom, did you have the question? Chisom? I think we
are Chisom on mute.
Thank you.
But it's on now.
Thank you very much. Okay, this one is a bit technical because the employee resigned based on what she heard and not based on what was actually done to her. So it's almost as if she acted on hearsay, if you may. So the resignation in this case, in my view, seemed voluntary. I don't think you can go around and say, I heard that this was being done to other employees, so that it is not done to me, I will resign. In this case, it doesn't seem to me like anything has been done directly to the employee or to the extent that we now force the employee to resign. The employee resigned based on what was being done to other people. Even though she was invited to the meeting, you cannot say beforehand that you are sure that she was going to be terminated at that meeting. You will never know. I think, to me, it seems like there was some sort of assumptions that led to this resignation. The resignation on itself is effective. Yes, it can take effect immediately, even if the employer had typed the letter of termination in advance that day and the employee resigned ahead of time. Yes, the resignation stands. The employer cannot challenge it. But to claim that the employee resigned because the employer was terminating the employment of other employees, it's a bit dicey. It's not one that I particularly see a lot of success in. The court may look at it as if the employee resigned based on hearsay or based on acts that was being done to other people. It's different if the employee was there and was watching it happen, and it was clear by all indication that it was going to happen to the employee in a manner that seriously breaches the terms of our employment contract, then perhaps the case may be different. But for her to be at home, hear about what happened to some people, and then resign because she felt she was taking a step ahead of the employer, and based on something that has not been done to her directly, I am not very sure she will succeed or he will succeed on that ground.
In other words, the law agree with the Yoruba proverb that says the death that is killing 200 people before you is telling you, giving you a hint to be careful.
Anyways, thank you all so very much for today's session. Thank you, Chisom. Fantastic presentation. We all learned a lot from you. Thank you from all our participants. Amazing questions, which added to the robust conversations that went on. If you have any okay, do you know, I didn't realize I was on mute, and I had given my whole thank you speech. I'll start again. So thank you all very much for attending. Thank you, Chisom, for a very beautiful presentation. Thank you, participants, for the lovely questions, interesting questions that did make this conversation very robust and enriching for all of us. If you have, we can't take any more questions. We have really overshot our time by about 18 minutes. If you have any more questions, please send us an email at elannigeria@gmail.com, and we'll try our best to come back to you. Jamu had already put on the group, and just in case you didn't say it, if you would like to be a member of this association, which is open to all practicing lawyers in Nigeria, please send us an email also at elannigeria.com, and we'll consider your application. And on this note, thank you so very much, and see you at our next webinar, same time next month.
Thank you, Mary. Thank you, everybody, for coming.